Hello and welcome to Awareness Self-Directed Training. The topic today is Nova Scotia Occupational Health and Safety Act, and this is mini module 10, and we'll be reviewing the content in sections 66 to 72. This is one of a 12 module series. So the first thing we're going to talk about is the powers to require a code of practice. So sometimes the code of practice is established in industry. It's industry specific, and it's really taking those best practices. And that sometimes, aside from the act and the legislation, the Department of Labor can hold organizations to follow the code of practice. There is no current code of practice for healthcare and community services, but it is in other sectors like forestry. So the director may, in writing, require an employer to establish a code of practice or adopt a code of practice specified by the director. The code of practice established or adopt may be revised or required to be revised from time to time by the director. So there's a very short section on that. We're now going to talk a little bit about appeal. So if an officer writes an order, the organization has an opportunity to appeal it, and this is sort of the process and the parameters around that. So for appeals, to review the orders of decisions for the purpose of this module, the term alter means vary, revoke, or suspend the order or decision of an officer, or make any decision, order, or decision that an officer may have made under the Act or regulations. So the director may review the order or decision of an officer and, by order, alter an order or decision of an officer after first consulting with the officer. So when reviewing an order or decision of the officer, the director may consider new information that was not available to the officer when the officer made the order or decision. The director is not disqualified from reviewing an order or decision by reason only that the director, in the course of performing the director's powers, duties, and functions related to the Act, receives information regarding or communicates with persons concerning the matter in which an order or decision, as the decision relates. Where the director alters an order or decision of the officer after reviewing it, the director shall provide a copy of the director's order to the employer, the person to whom the officer order or decision was issued. If an appeal was made to the Labor Board because the director's order was issued after the filing notice of appeal, the board shall be provided a copy. The employer shall communicate the order by posting it in accordance to the rules to post, which we covered back in Module 5. The Labor Board, the board shall hear all appeals filed under the Act and regulations. Persons appointed to a panel of the board must have knowledge and experience in the matter of occupational health and safety. The director has standing as a party in any case, and that is appealed to the board. The right to appeal and the consequences of appeal. A grieved person may appeal an order by an officer, the decision of the of an officer not to issue an order, the decision of an officer to advise an employee to return to work, or decision to provide no advice, an order made to the director, any decision from which a right of appeal is provided to the regulations. When an order or decision of the officer is appealed to the board and the director subsequently alters the decision, the appeal of the order or the decision of the officer is terminated. The appeal must be filed with the board within 30 days after the order or the decision served to the recipient. Continuing on appeals, the notice of appeal shall identify and state the order and the decision appealed from, set out grounds of the appeal and the relief requesting, including any request for the suspension of all portions of the order and the decision appealed from, and to include any other information required in accordance with the regulations. The appeal shall be posted by either the grieved person, if they have the authority, or the employer. When a notice of appeal is received, the board shall provide a copy to the director. The board should hold a hearing providing the grieved person an opportunity to present the evidence and make representation. The board may confirm, vary, revoke, and suspend any order or decision appealed from, or make any order that an officer is empowered to make in relation to the Act. An appeal of an order or decision does not suspend the operation of the order or decision. Continuing on with the appeals, the board shall provide a copy of the decision to the employer, the grieved person who appealed, any other grieved person who has made representation in relation to the matter appealed, and the director. The employer shall communicate the decision by posting it in a visible area in the workplace for all employees to view, and provide a copy to the safety representative or the JOSH committee member. When a grieved person has one or more appeals pending before the board may hear the appeals together, but shall render a decision separately for each appeal. The decision of the board is final and binding and not open to review except in error of law and jurisdiction. The review of the decision of the board shall be conducted by the Nova Scotia Court of Appeals, and with recognition that a panel of the board is constituted for the purpose of the Act as an expert body. So then we move on to the enforcement of the order or decision. A final decision or order of the arbitrator, an officer, or the director or the board regarding a claim may, for the purpose of enforcement, be registered with the Supreme Court of Canada and shall be enforced in the same manner as a judgment of that court. To register a final decision or a final order to the Supreme Court of Nova Scotia, the director may make a certified copy of the decision of the order and endorse it with his or her signature. The director may forward a certified copy endorsed to the designated representative of the Supreme Court of Nova Scotia, who shall enter it into the record and shall be registered with the Supreme Court and enforceable as a judgment in that court. The director may request that the Director of Labor Standards to enforce the final decision of the order in an officer, the director and the board regarding a complainant that an employer has failed to pay wages, salaries, benefits, or entitlement. Note that there is information on this being left out in this presentation relating to the Director of Labor Standards and the Labor Standards Codes. If you wish to review these items, please refer to Section 72, subsection 5, 6, 7, and 8. That is the end of mini module 10. Now please complete the post assessment. If you get all of the questions correct, you will get a message back saying thank you. If it says try again, it means you've got one or more of the answers incorrect. Please try again and submit until you receive the thank you back that you've got it, have it complete. Thank you.